All right, today we're going to review Utah Code Section 30-3-37. This is the relocation statute in the state of Utah. And it's an important statute because if things change in your life, you need to relocate from the state of Utah or move simply 150 miles away from the other parent, then this statute is applicable in your case. Now, it's also important to review any temporary orders or any other custody orders or divorce decree in your case, if there is one, to make sure that you're complying with the terms of the decree, which may have provisions that are different than this relocation statute. Also, if you have a mediation settlement agreement, you ought to review that as well. All right, so 30-3-37 at the time this recording is taking place, which is 2016. Includes several provisions. I'm going to go through those in detail. The first subsection 1 says that relocation means moving 150 miles or more from the residence of the other parent. So what that means is if you're not moving 150 miles or more, then the relocation statute really does not apply. We're looking for moving 150 miles or more. So get on Google Maps or use MapQuest or another favorite map program and figure out, or drive it, figure out if the distance you're moving is 150 miles or more. If so, then this statute applies. If it does not, then you can move on to other things and no longer waste your time watching this show. Moving on to subsection 2. Relocating parent shall provide 60 days advance written notice of the intended relocation to the other parent. The written notice of relocation shall contain statements affirming the following. That gives us a few lists. So keep in mind, at least 60 days advance written notice. Now, I've seen cases where 30 days was provided or more than 60 days. Look, you need to act in good faith. If you've just gotten a job offer and you need to relocate in 30 days, send something in writing right away. Make sure you comply with this statute. I will put the entire statute here in the description box so you can review it at your leisure, but you can also go to the state court website to review it or my website. That entire statute will be there. So look, this is the things you need to put in your notice. It must contain the parent time provisions in subsection 5 of the statute, or a schedule that you've both approved will be followed, and neither parent will interfere with the other parental rights pursuant to court-ordered parent time arrangements or the schedule approved by the parties. This basically means, hey, we're not going to interfere with the other parent's rights. We're still going to cooperate, get along, and hey, this has been our schedule, our parent rotation schedule that's going to be followed. And those things are important because you don't want to infringe on the other parent's rights. If you are moving just for the purpose of doing that, that means you're moving in bad faith. That's not going to be a good situation. Remember, the court reviews everything based on the best interests of the child standard. So you want to make sure that you're doing this not just for your benefit, but for the child's benefit as well. All right, subsection 3 says, the court shall, upon motion of any party, or upon the court's own motion, schedule a hearing with notice to review the notice of relocation and parent time schedule as provided in subsection 30-3-35 and make appropriate orders regarding the parent time and costs for parent time transportation. This is an important part of the statute because I believe that you should file a motion with the court and set a hearing if the court wants to hear it regarding relocation. Whether you are the one intending to relocate or the other party is, if you can't come to an agreement. The reason is because you want to have something in writing authorizing this from the court. If you simply do it of your own volition, it can be later determined that you didn't have the ability to do the relocation, and that could be a problem. You always want to have things done under color of a court order, unless you can get the other party's signature in writing. Agreeing to it. So as this says, is upon a motion, you file a motion, you can get a hearing, and the court will review it. The court can also assign who pays for what travel expenses, and we'll get to travel expenses in a moment. All right, subsection 4 says, in a hearing to review the notice of relocation, the court shall, so just focus on that word shall, it means they have to do it. It's not discretionary, it's not a may, it's a shall. The court shall, in determining if the relocation of a custodial parent is in the best interest of the child, consider any other factors that the court considers relevant to the determination. If the court determines that relocation is not in the best interest of the child and the custodial parent relocates, the court may order a change of custody. Now, that gives the court the ability to make a change of custody. It doesn't mean they will necessarily do this. The last custody relocation case that I had was very, very hotly disputed. One of the hottest disputed custody cases I've ever been involved with. And let me give you just a little bit of explanation as to what happened there. The parties had entered into a stipulation, a mediated stipulation and settlement agreement before they were divorced, where they were provided joint custody. I represented the mom. Opposing counsel represented the dad. Dad had a prior drug addiction, which at the time that we were looking at relocation didn't have the drug addiction at the time. At least he provided a clean drug test. But he had not been exercising even the minimum standard parent time with his two children. He'd been essentially doing one overnight every other weekend, which was essentially 2 overnights in a month. Now, for those of you who don't know, when you're doing a joint custody situation, joint physical custody, you essentially need to have a lot more overnights. You need to have over 111 overnights in a year. And so in a month period, you need to have a good 10, 11 overnights at least in a month to be able to say, hey, you're in a joint custody situation. And this guy was doing 2. So when we went to the court hearing, even though the law of the case, even though the divorce decree said joint physical custody, and this is going to be the parent time, because they had been acting in a different way for so long, and at the point of this case, it was 3 years. Because they'd been doing this for 3 years, that's what the kids were accustomed to. And they had created, according to the court, a de facto parenting arrangement, meaning, hey, even though the paperwork says something different, the parties acted differently, and therefore the court did not make a change of custody, but determined it was in the best interests of the children to relocate with mom, and it was also better for her employment as well. I mean, there were several factors the court looked at, and we, of course, briefed all of those factors. You don't want to just rely on one argument. You want to make as many as you can when there's a custody determination being made. But you enjoy, and I think you appreciate what subsection 4 here says. It says, hey, judge, you shall make a ruling based on the best interest of the child, but you can also consider any other factor that the court considers relevant to that determination. And so in that case, the court did. And in your case, if it's disputed, the court will do so as well. All right, moving on to subsection 5. If the court finds that the relocation is in the best interest of the child, the court shall determine the parent time schedule and allocate the transportation costs that will be incurred for the child to visit the non-custodial parent. In making the determination, the court shall consider, and it gives us some subsections. It shall consider the reason for the parent's relocation. Is it simply because the parent wants to? Is it because they're going to move closer to family, perhaps cousins or other extended family? Is it job relocation? That the court will take into consideration. Subsection 5b says the additional costs or difficulty to both parents in exercising parent time. So court will take that into consideration. How far away will determine the cost, right? Is it 153 miles away, or is it completely across the country? So that the court will take into consideration. Subsection 5c says the economic resources of both parties. So the court will look at perhaps new financial declarations from both parties to see if they are able to afford this new schedule that the court's going to put in place. And subsection 5d says other factors the court considers necessary and relevant. So again, any other factor that you believe relevant, make sure you speak to your attorney about it so they are aware, so they can say, hey, yeah, this is relevant. Let's use that. Let's use this as something in court. Or, hey, that's not so good, and let me explain why. All right, moving on. Subsection 6 says, unless otherwise ordered by the court. Now, this is why sometimes the legislature does a good job, is they're going to now provide us a parent time plan in a relocation situation that the court can simply rely on, unless the court finds a reason to do otherwise. So, subsection 6. Unless otherwise ordered by the court, upon the relocation as defined in subsection 1 of the parties of the following schedule shall be the minimum requirements for the parent time of children 5 to 18 years of age. So subsection A says in years ending in an odd number. the child shall spend the following holidays with the non-custodial parent: Thanksgiving holiday beginning Wednesday until Sunday, and spring break if applicable, beginning the last day of school before the holiday until the day before school resumes. In years ending in an even number, the child shall spend the following holidays with the non-custodial parent: the entire winter school break period and the fall school break period, beginning the last day of school before the holiday until the day before school resumes. Extended parent time equal to 1/2 of the summer or off-track time for consecutive weeks. The children should be returned to the custodial parent home no later than 7 days before school begins. However, this week shall be counted when determining the amount of parent time to be divided between the parents for the summer or off-track period, and 1 weekend per month at the option and expense of the non-custodial parent. So that is the minimum parent time that the non-custodial parent, meaning the one that's staying in Utah or the one that's not relocating or moving, gets. Now, remember that 1 weekend a month, that's at the option and expense of the non-custodial parent, meaning, hey, if you want to exercise that 1 weekend a month, you got to pay for it. So keep in mind if you're a non-custodial parent, unless, of course, the court orders otherwise, which is always something interesting and important to consider, because if the court orders otherwise, you're going to follow the court order and not the statute, okay? The next section here is subsection 7, which says the court may also set a parent time schedule for children under the age of 5. So remember, that section that we just went over is kind of the default for children 5 to 18. Now, if you're under 5, this is what the court's going to do. The schedule shall take into consideration the following: the age of the child, the developmental needs of the child, the distance between the parents' homes, the travel arrangements and cost, the level of attachment between the child and the non-custodial parent, and any other factors relevant to the best interest of the child. So there the court gives, hey, you can do, or the legislature gives the court direction as to different items to consider in making a determination when the child is under 5. All right, subsection 8. The non-custodial parent's monthly weekend entitlement is subject to the following restrictions. So this is the monthly weekend restrictions, okay? Here it is. If the non-custodial parent has not designated a specific weekend for parent time, the non-custodial parent shall receive the last weekend of each month unless a holiday assigned to the custodial parent falls on that particular weekend. If a holiday assigned to the custodial parent falls on the last weekend of the month, the non-custodial parent shall be entitled to the last weekend of the month. Okay, so you get that. If there's a holiday that's going to the custodial parent that includes the last weekend of the month, then the default weekend is going to be the prior weekend before. Okay, now by default it is the last weekend of the month unless the non-custodial parent designates it. So you need to designate it. How do you do that? You send an email, you send a text message, you make a phone call, you do all three, and you do them at least 30 days in advance so the other party is aware. All right, moving on to subsection 8B. This is also one of those restrictions for the non-custodial parent's monthly weekend visit. So that's what this applies to. 8B says, if a non-custodial parent's extended parent time or parent time over a holiday extends into or through the first weekend of the next month, that weekend shall be considered the non-custodial parent's monthly weekend entitlement for that month. Okay, did you get that? That essentially says that if you're already with the non-custodial parent, if the child's already with the non-custodial parent, and that time period goes through or includes the first weekend of the next month, then hey, that is the 1 month, that 1 weekend visit, that extra weekend visit that you're entitled to. All right, subsection 8C is the last of the restrictions for the monthly weekend visit for the non-custodial parent. It says 8C, if a child is out of school for teacher development days or snow days after the children begin the school year, or other days not included in the list of holidays that we've previously listed in subsection 6, and those days are contiguous with the non-custodial parent's monthly weekend parent time, those days shall be included in the weekend parent time. What the legislature has done here is basically provided the non-custodial parent some extra time if that time period would be included in the non-custodial parent visit. So they're basically allowing you to tack on a little bit of time. So they're basically, it says they are going to be given. It's a shall, not a may. So they shall be included as the weekend parent time. Okay. There's only a few more subsections. There's 15 subsections in all. We're now moving on to subsection 9. I apologize for the length, but as I've said before, it is somewhat complicated. We need to go through it in depth and in detail so that you're aware of it. And of course, this does not constitute legal advice because I don't know all the facts of your case. It's impossible for me to give you legal advice without knowing the facts. The facts are extremely important. Your situation matters. All right, subsection 9. The custodial parent is entitled to all parent time not specifically allocated to the non-custodial parent. So that basically means, hey, whatever we didn't give to the non-custodial parent, that belongs to the custodial parent. That's pretty straightforward. Subsection 10, in the event finances and distance preclude the exercise of minimum parent time for the non-custodial parent during the school year, the court should consider awarding more time for the non-custodial parent during the summertime if it is in the best interests of the children. Okay, so again, the best interests of the child test governs everything, but hey, judge, pay attention here. If finances and the distance aren't going to allow one of the parents, the non-custodial parent, to exercise the parent time like they're supposed to because they're just too poor or it's just too far, it doesn't work out, hey, court, maybe you should give him some more parent time during the summer or at other periods of time. So the court can make different determinations. A custody evaluation can also be performed. We're not going to go into that right here and now. We're just going to review the statute. But keep in mind that you can always ask the court for custody determination by a custody evaluator. Get a custody evaluator appointed. Yes, they're expensive. They're going to run you $3,000 to $5,000 on your side, $3,000 to $5,000 on the other side at least. But it is worth doing if you need to get a determination that's different than this, because most of the time, I would say 99% of the time, court's going to rely on this unless the situation's somewhat different. This is the kind of the backup standard what the court does. All right. Subsection 12, it says, unless otherwise ordered by the court, the relocating party shall be responsible for all the child's travel expenses related to subsection 6A and B and half of the child's travel expenses according to subsection 6C, provided the non-custodial parent is current on all support obligations. If the non-custodial parent has been found in contempt for not being current on all support obligations, the non-custodial parent shall be responsible for all of the child's travel expenses under subsection 6, unless the court rules otherwise. Reimbursement by either responsible party to the other for the child's travel expenses shall be made within 30 days of receipt of the documents detailing those expenses. All right, this is important because this talks about who's paying. Money is always important in relocation situations. So this says by default, unless of course the court orders otherwise, subsection 6A and B is what the relocating party, meaning the custodial parent, whoever gets that child and is relocating with them, they got to pay the expenses in 6A and B. What are 6A and B? 6A and B are the standard parent time for Thanksgiving holiday in even or in odd years and spring break in odd years. Okay, spring break and Thanksgiving, odd years, and in even years it's the winter school break and the fall school break. Okay, those are in even years. That means you, the custodial parent, are going to pay the round trip ticket or are going to pay the gas. You're going to pay the travel expenses. But you do not have to pay the expenses of the monthly weekend visit, and you only pay half of the weekend visit that is the summertime. So usually what we recommend is that the receiving party pays the cost of travel for the summertime. So that means if you're the non-custodial parent, you're going to pay the cost to get the kid, and then when the custodial parent wants the kid back, they're going to pay the cost, that half. Now, of course, you probably were paying attention. Your ears might have perked up that said, hey, if you're not paying your child support, non-custodial parent, if you're not paying your child support, guess what? You're probably going to have to pay for all of the child's travel expenses. Matter of fact, that's what it says. So you need to, as long as you're current on child support, pay half of the summer visits, all of the monthly weekend visits, and then the custodial parent or the one who's relocating, they're the one who's responsible for all travel expenses outlined for those holiday visits. All right, moving on to subsection 13. The court may apply this provision to any pre-existing decree of divorce. So that means, hey, you may have a decree of divorce, but we can go to court, we can change it again. And subsection 14, any action under this section may be set for an expedited hearing. That means, hey, if a party needs to move quickly, we can request an expedited hearing. This is important because sometimes you get a job offer, you need to move quickly, you don't have a lot of time. So you can, of course, file a motion, get an expedited hearing before a court commissioner or a judge, depending on the county that you're living in, the district court, where the court is, or some courts here in Utah don't have commissioners, but those in Salt Lake and Provo, Utah County do. All right. And of course, subsection 15, which is the last one, says a parent who fails to comply with the notice of relocation in subsection 2 shall be in contempt of the court's order. Subsection 2 says that you'll provide the 60 days advance notice that we talked about before. Hello, that's an important one. Don't fail to give notice. You want to give notice, because if you don't give notice, according to this, you shall be in contempt of the court's order. So this is a brief overview. Well, maybe not a brief one, but it's an in-depth overview where we haven't reviewed any of the case law, but we just reviewed the statute 30-3-37 in the state of Utah in 2016. That's what it is. If you're reading this or listening to this after 2016, the law may have changed. You want to give our office a call so that we can go over your factual scenario and we can apply this law to your facts, and that we can help you, give you good legal advice as to what would happen in your case. We enjoy representing family law clients. We enjoy relocation cases. They are the most fun in my mind. Anyway, give our office a call, 801-676-7309. We'd be happy to assist you with your relocation case. Thanks for watching.